Oh, all within the course of the last 24 hours, we've got a temporary restraining order by Judge Ilston in San Francisco against the Trump administration and about 24 different agencies to stop them from continuing to, quote unquote, restructure the federal government, fire people, either through the three major tools of Donald Trump or otherwise. We know his three sledgehammers, and so does Judge Ilston in San Francisco. The Office of Personnel Management, the Department of Government Efficiency, the Office of Management and Budget. All three of those sledgehammers, there's nothing else in Donald Trump's toolbox, are being used by Donald Trump to, quote unquote, dismantle and reorganize the federal government. And Judge Ilston says not without Congress's approval, that all of the agencies that you are restructuring and all of the employees you are dumping out into the street and all of the services that you are cutting off, disrupting provision of services that are critical to Americans who rely on them, all of that you got to do with congressional approval, because those agencies are creatures of statute. Statutes are laws. Laws are created by Congress. Only Congress can change them. Or as Judge Ilston said, citing to the Federalist Papers back at our founding of our great country, you can't have the same person be the legislative branch and the executive branch without inviting tyranny. I'm Michael Popok. I'm not going to invite tyranny. I'm going to call it out here on Legal AF, the YouTube channel. Take a minute, hit the free subscribe button, and that will help us continue to grow this community. Let's get to Judge Ilston. We've got her temporary restraining order, and of course, we've got the appeal by Donald Trump right after it, later that same day, to the Ninth Circuit Court of Appeals. But let's start with the suit. Take us to the temporary restraining order. Talk about the date for when the judge is going to consider the preliminary injunction, which is next up on the food chain, and then what happens with the appeal. Let's start with the filing of the lawsuit. Back on the 28th of April, the AFL-CIO, the largest labor union in the country, along with a group of public interest groups, filed the suit in Northern District of California. It's a friendly forum, and in San Francisco. San Francisco strikes again. I can't tell you how many, it's been over a dozen injunctions, key injunctions, have been obtained in the San Francisco Northern District of California Court. Now, let me read to you from the complaint so you know what we're talking about. This is the pleading that starts off the process. Again, dozens of agencies, including the Office of Personnel Management, the Office of Management and Budget, run by Russ Vought, who was one of the architects, if not the father, of Project 2025 and the Heritage Foundation. He runs the nation's checkbook on the executive side through the Office of Management and Budget. Here's what the complaint says on page 6. The president does not possess the authority to reorganize, downsize, or otherwise transform the agencies of the federal government unless and until Congress authorizes such action, because federal agencies are creatures of statute, citing to a United States Supreme Court case from 2022. That very concept is at the heart of Judge Ilston's analysis, but it shows up first in the complaint. When the president, the complaint continues, takes for himself the legislative power to recreate federal agencies in the manner he sees fit, he violates the Constitution. There can be no liberty where the legislative and executive powers are united in the same person. Quoting James Madison in the Federalist number 47, thus, for nearly 100 years, when presidents have wanted to restructure the government by reorganizing both between and within federal agencies, they've obtained congressional authorization to do so. That's the very thing that's missing with Donald Trump. So when they go through on page 9 of the complaint, they say at paragraph 10, again and again, the president has explained his plan to reorganize and reform the entire federal government. I got elected on the basis of making our government stronger and smaller because we have millions of people that shouldn't be paid. At no point, paragraph 11 of the complaint alleges, which it resonated with Judge Ilston, at no point has Congress authorized President Trump's actions with respect to the federal agencies created in exercise of its Article 1 legislative authority, which the Constitution grants to Congress, not to the president. Unlike President Trump, 9 presidents on 16 occasions across the political spectrum have been granted authority by Congress to propose legislation before reorganizing agencies. And then they list the presidents: Hoover, Roosevelt, Truman, Eisenhower, Kennedy, Johnson, Nixon, Carter, Reagan. Trump is not among that group. So that complaint gets filed along with a request for a temporary restraining order and a preliminary injunction. A temporary restraining order, because we already have over 150 of them against the Trump administration, just as a reminder or a primer, is the court early on in the case looking at a limited record based on evidence before him or her at the time, decide that the 4 factors to satisfy an injunction are present, that the party will be irreparably harmed and has an inadequate remedy at law unless the judge uses her powers of equity to stop or block or force something to happen. That there is a likelihood of success on the merits, meaning she's peeked under the hood, she's looked at the evidence, she's looked at the legal arguments, and she thinks it's more likely than not that the plaintiffs, the moving party for the injunction, will prevail at the end of the case. It's a little bit of a prediction, but it's based on the record before her at the time. Those are the 2 major components of the 4 elements that are evaluated for an injunction. Likelihood of success on the merits, you're going to win, and you're being irreparably harmed, and I need to fix it now, and money can't fix your problem. And the judge went through in her order all of the irreparable harm, which is basically Donald Trump cutting the umbilical cord or the connection between people and their government, and people who rely on federal benefits and federal powers and federal activities that can only be provided by the government. So that was the suit that was brought. We then had the briefing about the temporary restraining order. And just yesterday, we now have the order, 41 pages from Judge Ilston, who is I believe a Clinton appointee. Let me just check. A Clinton appointee, senior status judge, and granting the temporary restraining order and also compelling certain information to be provided by the government to support the next round, which is the preliminary injunction, which stays in place until the end of the trial. When usually a temporary restraining order, which is good until the judge gets around to making her final ruling on the preliminary injunction at the end of the month, usually that's not appealable. But I will tell you in advance of the end of this hot take, the Trump administration has attempted to take an appeal to the Ninth Circuit. I think that gets rejected because the temporary restraining order is not proper for an appeal. They need to wait until the preliminary injunction. In the meantime, for at least 14 days, the judge has blocked the Trump administration and all of its agencies from continuing to reorganize, fire, close, shutter field offices, put people out on the street, and anything else until the judge is done. Here's what the judge says in her order, which I found very important, and I wanted to go over it with you now. Pages 1 through 4 sort of summarize her position. It says on page 1, this is the judge's order now, the new presidential administration has made clear that it intends to change the way the federal government operates. Federal courts should not micromanage the vast federal workforce, but courts must sometimes act to preserve the proper checks and balances between the 3 branches of government. As a group of conservative former government officials and advisors have written to the court in a friend of the court brief, unchecked presidential power is not what the framers had in mind. So again, just like Justice Roberts in a recent interview, she's saying, I'm not going to micromanage the federal government on the executive branch, but there's a role for the judiciary to check excesses and abuse of power by the head of the federal branch, which is the president. She then goes on, the judge goes on to grant the temporary restraining order. She says on pages 3, she then goes through examples where the federal government has gone too far, cutting services so badly that people are suffering. Now, let's get to the meat of her order on page 26 and 28. On page 26, she says, actions by President Trump. Plaintiffs are likely to succeed on their claim that the president's executive order is ultra vires, meaning it abuses his power is beyond the limits of his power, as the president has neither constitutional nor at this time statutory authority to reorganize the executive branch. That means she agrees with the plaintiffs that in order to do this federal court reorganization, the presidency needs the support and the approval of Congress, and he does not have that. In the framework of the Constitution, the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. The Constitution limits his functions in the lawmaking process to the recommending of laws he thinks wise and vetoing of laws. He can recommend, he can veto, but Congress has to propose. So that's where the whole restructuring comes in. At the end, after she cites to the history here, she then concludes, the court concludes, this is on page 42, the court concludes where it began. The president has the authority to seek changes to executive branch agencies, but he must do so in lawful ways and in the case of large-scale reorganizations with the cooperation of the legislative branch. Many presidents have sought this cooperation in many iterations of Congress. Nothing prevents the president from requesting this cooperation as he did in his prior term of office. Indeed, the court holds the president likely must request congressional cooperation in order for the changes that he seeks. And thus, the court issues a temporary restraining order to pause large-scale reductions in force in the meantime. She then set a briefing schedule through May, middle of May, on the preliminary injunction, and she'll hold a hearing on the 22nd of May. Of course, Donald Trump didn't want to wait. Randolph filed the Ninth Circuit appeal brief and a notice, and we'll have to see what the Ninth does. He may also go back and ask Judge Ilston to stay her order to allow for an appeal. I doubt she does that. He'll ask the Ninth Circuit for the same thing. I doubt they do that, although I'll have to see the 3-judge panel that's assigned. And then the loser of the Ninth Circuit will take an emergency application. That means Donald Trump to the Supreme Court. It'll go through Justice Kagan, who sits over the Ninth Circuit. I've been imploring the Supreme Court to use its powers of individual justices to refuse this emergency application when made. But we'll have to see what she's going to do. If she doesn't reject it on her own, she'll send it over to the full 9 en banc panel of the Supreme Court for them to rule. We'll follow it all. You're here on Legal AF. Thank you for being here. Hit the free subscribe button. Come on over to Legal AF, the Substack, where I'm posting all of these documents that I've been referring to in my analysis here. So until my next hot take, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.